Oh, sorry. Hang on. Oh, here it is. Sorry about that. Let's do slideshow. And go from beginning. It's pretty jam-packed today. I do like to have some, if you guys want to speak up, if you want to ask a question, there will be time at the end. But, you know, if you're like, oh my gosh, you know, unmute yourself and say, oh my gosh, you know, like it's kind of weird to talk to yourself for an hour without any kind of feedback, verbal or visual. So let's just get going. So this presentation provides legal information, but legal information is not the same as legal advice. Nothing in the presentation is intended to apply to any specific circumstance. We go to great lengths to make sure our information is accurate and useful, but you should not rely on that information as it relates to any specific legal problems, and recommend that you consult with an attorney for advice that relates to any particular situation you might have, or obviously a consultation with Compass HR. The agenda, we're going to talk about the emergency temporary standards as it relates to federal OSHA, Cal OSHA, the vaccine mandate, the Supreme Court of the United States, voluntary vaccine mandates. We're also going to talk about COVID reporting for workers' compensation, exposure notices, and outbreaks. We're going to cover some of the 2022 laws, including CFRA updates, wage theft violations, and confidentiality clauses. We're going to just review some things about your people, to talk about timekeeping a little bit, minimum wage, exempt salary, meal and rest breaks, and then we'll have some time for a summary and questions and answers. So we're going to talk about ETS stands for Emergency Temporary Standards. And we have federal OSHA and we have Cal OSHA. California is a state that has a separate entity that talks about health and safety and well-being in the workplace. So just because something is okay with the federal OSHA, California has its own rules. They're required to be more strict or more stringent than federal OSHA. They can't go and say, oh, well, we don't like this, so we're not going to do it. I mean, we all know in California that's probably not likely to happen anyways, but they can be more restrictive. So federal OSHA, we've had some changes in the last week, and I think I updated everything that needed to be updated. But we're going to talk about the vaccine mandate. So the vaccine mandate, I don't know if you all heard, but the Supreme Court of the United States overturned the vaccine mandate for companies with over 100 employees. There's a stay on that. That's not going to be required. It's going to still play out at the local court levels at the state. California OSHA is supposed to be meeting on the 20th, so this week, and talking about whether they're going to carry out that mandate. We'll see what happens. The vaccine mandate is still in place for federal contractors, as far as the last to my knowledge. As for federal contractors, there are still court cases going on with that, as well as for CMS workers, and that's the Centers for Medicare and Medicaid Services. Cal OSHA adopted emergency temporary standards, and they readopted last week. They made just some minor changes. And now that the court has ruled on the federal ETS, California has to update theirs to be equal or more strict. And again, they're meeting on the 20th of January. So just in a few days. So California's current rules for mandated vaccinations or test policies. So employers can, if you're in the medical field, there has been an executive order from our governor and from the California Department of Public Health that all healthcare workers need to vaccinate unless they have an exemption. And then they have until February and sometime to be boosted if they're eligible for boosted. And we'll kind of talk about those different things when we talk about returning to work rules that have just changed as well. So, but you can have a mandated vaccination policy in your workplace if you choose to. If you do so, you have to have a written policy that communicates that. The employers in California have to pay for all related costs to testing. So if you have a vaccinate or test policy, or you have a vaccination policy and allow those with exemptions to test, the employer has to pay for the testing, for the time spent testing, for any mileage, any expenses incurred as a result, because you in the Department of Industrial Relations says if an employer is mandating it, or if the government had mandated it, the employer in California is still on the hook to pay for those costs. Yes, you've given an exemption. That's just what they say. And anytime we're requiring employees to test, we do have to pay. Speaking of cats, I see yours. Anytime that we do require testing, we do have to pay for that. The employer has to consider exemptions. There are medical exemptions that have to be signed off by the employee's practitioner, medical practitioner, and there's religious exemptions. And we have to be careful when we are considering the exemptions. Religion, a lot of people say, well, I know they don't go to church, or I know that they don't believe that way, or I know this. Religion tends to not be a static situation. Someone might feel one way one day and feel a different way another day. So they urge caution if you're looking at those exemptions. And, we're looking at whether we're going to consider that or not. Right now, tests are really hard to come by. Whether you're trying to get the at-home tests, whether you're trying to do the free tests. I think the only ones you can get right in for is, I know COVID Clinic has openings, but that's for the pay, $129, the rapid tests. And then the employer also needs to pay for vaccinations if you make that mandatory in your workplace. If you don't make it mandatory and people are just showing you, we are supposed to be keeping records of those things. If we have them in the workplace, if you've mandated it, you really need to keep the records. If you're keeping the records, but it doesn't, okay, if you are vaccinated, back before the mask mandate kind of hit again, we were allowed to, okay, if you were vaccinated and boosted, you could go without a mask. If you weren't, you had to wear a mask, so obviously you want to keep those records just in case. Okay. So COVID reporting. Oh, I see something in the chat box real quick. Oh, yes, you can use home tests. What the caveat is with home tests is that they have to be proctored, which means if you have an employee who's doing a home test at home, they can't self-report. You could have them do the test in front of you and it's Zoom, and you just have to, you'd have to do something where you'd have to have your eyes on the test at all time to make sure they're not, switching. It has to be proctored in some way. So yes, home tests are allowed now. The antigen tests are allowed. And in fact, California Department of Public Health and CDC both have said antigen tests are preferable when you're trying to get a negative test after you've gotten a positive test, that they're a little more accurate for that. COVID reporting, it hasn't gone away. I know it's been a long road. I know we've been switching and shifting and moving since 2020. We still have to be doing these things. Some of these things are going to last all the way through 2023. So we've got to keep at it. The first thing we want to do, if an employee tests positive in the workplace and they report it to us, we need to send out a written exposure notice, and we need to do it within 48 hours of the report of COVID. And, it's written and it's given to the employees. If you normally email your employees, it can be given via email. If you normally hand employees notices, it can be handed to them. And it's just at the work site that the positive happened. So if you have multiple work sites, it's whoever reported there within 14 days. Okay. Then we have the workers' compensation reporting. You have to report to your carrier if you have positive cases in your workplace. You have 72 hours to do this, and most of them have online reporting tools that you can report. It doesn't matter on either one of those, whether the employee caught it at work or caught it at home. You have to report it either way. It has to be reported to your carrier. If the employee contracted COVID at work, it's different because if they contracted it at work, you might have to file a claim. It's different reporting for that. It's assumed or presumed to have happened at work unless we can ascertain that it happened outside of work. So always, if an employee or a client's employee, I talk to them and say, I'm so sorry you're sick. How are you doing? Are your symptoms severe? I care. Are your symptoms severe? Are they mild? What kind of support do you need? Do you know where you might have gotten this? I've had a very good record of having people answering appropriately, not, when their kids have had it, they're not saying, oh, I caught it at work. No, they're typically not saying that. Usually they're going to say, yeah, my husband has it and I caught it from him. If it was at work, file a workers' comp claim. There's also, if someone did catch it at work, there's exposure. You have to pay for their time and there's no tax credits. And I think there's probably I'm sure I have a slide on that. Sorry, this is not flipping. Okay. So we're going to continue. We're going to talk about other obligations. An outbreak is when there are 3 cases for AB 685, 4 cases for SB 1159. None of the different laws that occurred about reporting or anything else decided to get things together and decide what an outbreak is. For the California Department of Public Health, it's 3 cases. So I just typically always go with 3 cases, right? If we have an outbreak, it's 3 cases. It's not 3 workplace cases like they all got them at work. It means if you have 100 employees, it means you have 3 employees positive. If you have 3 employees, it means you have 3 employees positive. If it goes up above 100 employees, it's a percentage. So if you have 3 positives in a 2-week period, it's considered an outbreak, and you have to report it to the Department of Health, and you have to offer testing weekly to the employees who were in that exposed area. And actually, I'll talk a little bit about exclusion pay. If you have an employee who says, I don't know where I got it, or they say, I got it at work. I have a client right now. They had the first employee went to a wedding. He contracted it at a wedding. He didn't know. He came to work. He found out 2 days later that half of the guests at the wedding had tested positive. He left, but 3 of his coworkers tested positive 2 days later. I mean, it's pretty clear. Most likely they got it from him. They all have to be paid exclusion pay because they caught it at work, and their time away from work is paid not out of their sick pay, not out of their pay, their PTO, not out of any vacation. The employer has to pay that. You can try to mitigate that by asking someone to go ahead and apply for state disability insurance. However, there's a 7-day waiting period for that. And by the time you have a weekend in there on either side, it's not as, applicable. So, okay. For some reason, my screen is not forwarding my slides very nicely for me. There we go. Okay, so now we have new return to work guidelines, because it's not enough to, we were all used to the 10-day rule. We all kind of knew it. Okay, your symptoms start, you have, 10 days, and then you can come back to work. Again, keep in mind, I don't know if any of you have medical practices, but medical practices are very different, from this. So if we have someone who's COVID positive, and that means they've had a positive COVID test, or they've had a diagnosis of COVID by a medical practitioner, someone has to stay home for at least 5 days. These are the new rules. It's a little bit stricter than CDC's, but it's right in line with it. Isolation can end after day 5 if the symptoms are not present or they're resolving and a negative test occurs. This is where they're preferring that rapid antigen test, because what they're saying is that if someone's positive, the antigen test is more quick to show a negative than a PCR test. If you're not able to test or you choose not to test, isolation can end on day 10 as long as the symptoms are resolving or they're not present. If there's a fever present, we have to continue isolation until that fever resolves, and not like, oh, when I take Advil, my fever's gone, so it's okay. No, you can't be taking medication. If you have a fever, you've got to isolate. And then if you come back to work earlier than that 10 days, and we're all supposed to be wearing masks at work anyways, but they added in, if you're out and about, you need to wear a well-fitting mask around others for a total of 10 days, especially in indoor settings. The new thing with well-fitting is there's not supposed to be gaps. You're supposed to be able to hold your mask up to a light, and light is not supposed to shine through that. Okay. Here's where it gets a little tiny tricky, is when we're talking about exposure return to work. And this is where things have shifted a little bit. And vaccinated, unless they are boosted, are considered in the same bucket as non-vaccinated. So if you have someone who's not vaccinated or someone who's vaccinated and booster eligible but didn't boost, this is their bucket. Stay home for at least 5 days after your last contact with a person who has COVID. So if you have someone in your house with COVID, every day you're with that person in your house, it's considered a day of exposure. You have to wait until their exposure period is done or their infectious period is done before your 5 days starts. So my son was COVID positive over Christmas. My quarantine didn't start when his started. Mine started when his ended. So I was out many more days than he was because I had to stay home 5 additional days. Then I had to test on day 5, and I was asymptomatic and I had a negative at that point. So I was able to come back. If someone is not able to test or they're not willing to test, quarantine can end on day 10 if asymptomatic. Again, day 10 after, they are considered non-infectious. You have to continue to wear a well-fitting mask around others for a total of 10 days, especially in indoor settings. And we're all supposed to be wearing masks in the workplace right now. Anyways, if you're boosted or you're vaccinated but not yet booster eligible, you don't have to quarantine. You would still test on day 5, and you would wear that well-fitting mask around others for 10 days, especially in indoor settings. Now, I shift a little bit on the air of caution from the California Department of Public Health and CDC. I'm seeing way too many boosted and newly vaccinated who are still having it and spreading it. And so in our workplace, if you've been exposed, you're just not coming to work until you hit that day 5 and you can test negative. That's just, you can always make more restrictive guidelines. So I know it's tough, but you don't have to do my way. I would prefer to have the whole office. Do you have a question? Okay. Okay. So now we're going to talk about major laws for 2022. Hopefully, we've all heard about California Family Rights Act leave, or CFRA. So last year in 2021, it used to be, before 2021, only employers who had 50 or more employees within a 75-mile radius qualified for this leave. Hannah Beth Jackson she's retired now, but she had really been pushing to bring this down. And it came down to any employer who has 5 or more employees. It was a big jump. Usually we'll see it go from 50 to 25 to maybe 15, and kind of work its way down. The reasons for this leave would be to bond with a new child, and that could be an adopted child, it could be a foster child, it could be a child of your own. care for a family member with a serious medical condition, care for your own serious medical condition, or for a military exigency. So it is job protected, unpaid leave for 12 weeks every year. Right here, handbook policies are key. If you don't have a CFR policy, I highly advise you to have one. If you have 5 employees on payroll, if you have your kids on payroll, those are people on payroll. Okay. They also have to be, they also have had to be employed for a year and work 1,250 hours in the last year. If you don't define what a leave year is, they're going to define it for you as calendar year. So someone could be out October, November, December, and again qualify for January, February, March, and you have to hold that now for 6 months. You might be okay with that. I prefer to really define that leave year from leave year to leave year. So if I have a baby and I have my baby in, and we've got all different kinds of things. So then we'd have pregnancy disability leave. I have my time out that's protected when I'm disabled by pregnancy. Then that ends, and then I want my baby bonding time. Let's say my baby bonding time starts in March. So I have 12 weeks, March, April, May. I could also take it intermittently if I wanted to do that. Once I've exhausted that, I'm not eligible for another 12 weeks of unprotected leave until the following leave year, which would start in March. So it would be leave year to leave year. That way you don't have someone kind of getting the 6 months all in one shot. If you have more than 50 employees, there are going to be some intersections with FMLA. And changes this year include family member, also includes parent-in-law. They did try to sneak in a designated person. However, that one was not passed. That it allowed an employee to designate a person every year in case they needed care, and that you could care for that person. Now, there's other leaves. If we're talking about using it for baby bonding, someone could be out on pregnancy disability leave and be using state disability to partially pay for that. And then they could be out on the baby bonding portion, and they could use paid family leave through the state to partially pay for that. Sometimes what I'll see people do is take their baby bonding, that 12 weeks, and stagger it with their spouse or their significant other, and each one takes 2 weeks off every month and staggers it for 6 months. And then baby doesn't have to go to daycare for quite some time. I've seen that happen as well, where they'll stagger that, and it is protected. Another law that passed was AB 1003, and it's wage theft violations. Wage theft, it sounds like it's like such a serious thing. And we don't know. A lot of attorneys are saying, maybe it's not going to be such a big deal because it has to be intentional. I prefer let's side on the air of caution, because I don't want any of my clients to be the poster child for how this is going to get defined in the courts. I prefer to try to keep people out of court as much as I possibly can. So with wage theft violations, that's failure to pay overtime, not paying a missed meal break. It could be not paying a missed rest break. It could be my employee took a phone call for 10 minutes and I didn't pay them for that. I didn't know they took a call for 10 minutes, but I didn't know. What they're saying now is that any kind of wage theft is considered grand theft. So it's criminal. It's a felony. Although the law says it has to be intentional. That's where I think people are okay, well, that's, intentional. Well, I don't know how hard that is to define. And they usually create laws like this, and then we figure out what the definition of intentional or not intentional. They might say, minimum wage just went up, and maybe you didn't change your minimum wage employees. Oops, I forgot. Maybe they would consider that intentional because you should have known. I don't know. We just need to be very careful with any kind of wage. It was a highly litigated thing to start with. And so we just need to be even more careful these days with that. Okay. We also have SB 331 confidentiality clauses. So what that law says is you want to have your severance agreements or your settlement agreements really looked at very closely. Please have an attorney look at those. As an HR consultant, I do not do severance or separation agreements. I do not do any kind of settlement agreements. That is a legal document, and you are really better served having an attorney look at that. What it does is it does not allow for there to be a confidentiality clause in any kind of fee haul claim. And a fee haul claim is going to be discrimination, harassment, abusive workplace, those kinds of things. And so if you have an agreement that asks for confidentiality, they could throw your whole agreement out. We want to make sure we have those in place. Please have an attorney look those over. Okay. I'm going a little fast. I can kind of pause here for a second if we have some questions on anything that we've discussed up till here. And I can't see all of you. But if you have a question, go ahead and you can speak up. Okay, I'm going to keep plugging away then. So for your people, we want to make sure we're keeping accurate time records. Time records are so important. And I do have a lot of businesses that I come in contact with where the business owner or the manager will say to me, they just get paid for 8 hours a day, but they really don't work 8 hours. They're usually working 7.5. They're usually working, 7. As long as they get their work done, I really don't care. So I don't want to keep track of their time because I want them to have flexibility. That sounds nice. And probably for some workplaces, it would be entirely appropriate. And the employees probably might work more given that kind of flexibility. However, we're in California. And I do not advise not keeping track of time. And I mean keeping track of time. 8:01, Sally arrived to work. 11:46, Sally took her lunch. 12:30, Sally clocked back in after her lunch. 4:30, Sally left for the day. Like, exact times are so important. It's important to reflect exactly when the meal break gets taken. These are things, and then it becomes, if you don't have the records, it becomes your word against the employee's word if it goes to the labor commissioner. And typically the employee wins. If the employer does not have hard proof with the timekeeping, it's not going to count. You can't, I've had people where they kept their record on a big calendar and they just wrote everybody's hours. That's more of a schedule. Really, your employee should be looking at their time record before payday and saying, yes, these are the time, this is what I worked. I took my meal breaks and my rest breaks, and I'm okay with this. It could be electronic. It could be a spreadsheet. It could be, there's different software apps that you can use. Meridian Payroll has a great timekeeping system that integrates with the payroll system. It could be something like that. At the end of the payroll period, that employee needs to look and certify that those hours are correct. Timekeeping is huge. And especially as we now are working telework more than ever, it's very important that your people are clocking in and clocking out for all hours worked. If they have to go get a COVID test and you're requiring a COVID test, or they were exposed at work, that's hours worked. All of it is hours worked, and it's so important. Minimum wage, we're at $14 and $15 right now for this year. They're supposed to make adjustments based on inflation and other things. That'll be the legislature or Department of Labor, but they'll let us know for 2023 what's going to happen on that. Exempt salary has also changed. In California, exempt salary, with the exception of outside sales reps and inside sales reps, and then some, upper level computer software executives and things, they're a little bit higher. is 58,240 a year. If you have 25 or under, if you have 26 and over, it's 62,400 per year. And you can't just say someone's salary and slap that sticker on them and say it's good. They not only have to pass that salary test, they also have to pass a duties test. You can't say, well, my receptionist is making $60,000 a year. I have 10 employees. It's okay. Well, unless your receptionist is making some kind of independent judgment decisions in the basis, during the workday, or is maybe, overseeing other employees, making some, is operating fairly independently, it doesn't matter how much you're paying them, they're not going to pass the duties test either. So there's the salary and the duties test. You can always pay someone who's non-exempt a salary, but they still need to be tracking their time, their meal breaks, all of it. Meal and rest breaks, this one's a huge thing. Meal and rest breaks in California are a huge thing that gets taken to court. In California, an employee is supposed to take a 30-minute, no less than 30-minute, unpaid, duty-free meal break by the 4th hour and 59th minute of work. With the exception of if they only work 6 hours and not 6 hours and 1 minute, not 6 hours and 2 minutes, they can waive their meal break, but only in writing. So there is an exemption with that. But if you have an employee who, and I've done it, my employee will say to me, hey, I want to do a 6-hour day today. Can I skip my meal break? Sure. For whatever happens, some emergency happens or something happens, and he is not going to get out by the 6th hour, I have to pay him an hour penalty because he did not get his meal break because he works over 6 hours. I'm okay with that because it's not a habitual thing with him. And I think he deserves that flexibility. However, if it was someone who was really taking advantage of it, or if I had multiple people doing this kind of flexible arrangement, it might be a little harder to manage. When I'm approving payroll, when it's time to approve payroll, I open up those timesheets and I'm looking, overtime is automatically calculated. I just double check to make sure it's calculated correctly. I'm also making sure that no one has worked over 4 hours and 59 minutes without a meal break. If they do, I just add an hour penalty in that. If it gets to start being a habit, I'm going to write them up for that, but they still get paid for that extra hour. If, let's say, someone was habitually doing it because they figured out it was a great way to get an extra hour of pay, or I really don't want to take a lunch. I'm an adult. I can eat at my desk. I'm not going to take a lunch and you can't make me. And they just do it, or they, I'm going to write, hey, Sally, you're supposed to be taking a meal break. I noticed you didn't. I'm going to pay you your penalty hour. If it happens again, I'm going to need to write you up. I understand you don't want to take a meal break. However, you're required to do it by law. If you don't want to eat, you want to eat at your desk, I'm happy with that. Go take a walk, or go outside, go do something, but you cannot work during that hour. Let's say it happens again. I write her up again. Hey, I saw you did this again. Here's a disciplinary action. If you do this again, I'm going to put you on an unpaid suspension. They do, now I've paid 2 extra hours. They do it again. So now I have to pay a 3rd hour, and I'm going to say, Sally, and it's not due for that part isn't due for overtime. It's a penalty pay. It's not considered hours worked for the penalty time. Sally, you've done this. This is the 3rd time. I'm going to have to suspend you without pay for 3 hours. I don't want to do it on a Friday. I'm not going to tell her. I'm not going to do it on a Friday afternoon because I'm certainly not going to let them get off and have a long weekend. I'm going to do it probably right in the middle of the week and say, on Wednesday, don't come in until 11. I'm going to try to be as, I don't want to say punitive, but I'm not going to reward it either. So there's that. And overtime in California, some people get this wrong, is anything over 8 hours in one day. And if you want to have an alternative work week, that's like working 4 days with 10-hour days. You can do that, but there's a process to do that. You can't just like wave a magic wand and say, hey, we're working an alternative work week. Okay. This is the end, and I just want to let you all know, Compass HR will offer a free HR checkup for all attendees who would like us to look at your HR processes. My number's up here. I know you will get a copy of these slides as well, so my information will be on there as well. And I
Daneen,
am going to close this
really
up.
quick.
Yeah,
Really quick. Do you have a couple? We have a couple questions in the chat. Would you be able to touch on those real quick?
absolutely. Let me just stop my share so I can see everybody. It makes it a little bit better for me. Can we use home tests? I said yes. On non-report or just a single case? Or does it have to be, oh, I think we're talking about the outbreak. I'm thinking for Shane. Shane, are you still on?
Yes, that was back for the when you were talking about that. You already said it was 3 people afterwards.
Okay, thank you. Does the salary amount include benefits and health care? No. It could include some bonuses, but only a certain percentage of the bonus. Now, if it's an outside salesperson, there's no base salary requirement, but you have to be careful because if you have an outside salesperson, they have to be spending at least 50% outside. And if their home is their office, they have to be 50% outside of their home trying to get these things done too. So we want to, I have some worksheets on that. So if you book an HR checkup, I'm happy to have that conversation with you. And look at that on a case by case basis. The outbreak count is in different households, correct? Or did that change? It is, I believe it's total employees in the workplace. And I could be mistaken. I never knew there was a household change or difference. Joanne, you can, if you want to talk, you can talk.
There we go. That's better. So if we have employees who work here who are part of the same family, so we have 2 people who work here from the same household, does that still count as 2 cases? Because I believe at one point it said different households. So
okay, and I can look that up. Actually, I was not. There are things that escaped my my knowledge
so much that it's.
Oh, I mean, my husband and I work in the same workplace. I'm at the end of mine. He's right at the very beginning of his. Yeah, it counts as 2. That I've been counting it as 2. Maybe it doesn't though. That one I'm not quite sure on. Any other questions, comments? It's free time. Anything else that wasn't presented that you have a question on?
Did you hit on that question in the chat? What are the rules for salary versus non? Did you see that one?
Oh, I do see. Yes, hang on. Oh, salary versus non. Yes. So we're talking about exempt versus non-exempt, I'm assuming, Sheila.
That's correct.
Okay, so for exempt salary, and I'll hit on some of them, we have the one that most people try to use is administrative exemption. The administrative exemption means that someone has to be in a position where they have some autonomy or some independence in the workplace, and they're making those base, the 58,240 or the 62,400. Those amounts, and then they have to pass the duties test. There are other ones for professional exemption, so doctors, lawyers. I've used it with some social workers, people that might have a license, they can be exempt. They still have to make that minimum salary amount, but because of the nature of their duties. Really, if you want to boil it down with the outside of the sales exemptions, it really has to do with autonomy and independence. An exempt employee really is going to be making some higher level decisions. Does that kind of answer your question?
Sort of.
Okay, ask me a little bit more.
More like, okay, I thought I read it somewhere and I can't find it, but like there's certain, like there's 3 duties. Is this person, can they fire, can they hire is one. can they do this? Can they do that? I can't remember the other two.
Yes, there's more than three. I actually have a whole worksheet on that one. But yes, can they hire and can they fire? That is definitely one of them. Are they, operating under only general direction from their immediate supervisor? Or are they, here's your list of things to do. You need to do this and then this and then this and then this. They're not going to look like they're exempt. That's another one of the questions. So really, if you think about it, someone who is autonomous and independent, they might be making marketing decisions for the company or purchasing decisions for the company, or they might be the person that makes the decision whether an HR consultant is going to come in or not, or, hey, we need to hire this position, and they're posting that and interviewing and making that decision.
Okay, that helps. Thank you.
Absolutely. But yeah, if you want to contact me after, I can always send you that worksheet too.
Okay, thank you.
Absolutely. Any other questions? All right. I'll let you take it back over, Amber, if you're ready.
All right, let me, oh, I just realized my video is not going. Okay. Well, thank you all for being here. Thank you so much, Daneen. That was a lot of really great information. I'm just fascinated by all things like that, especially when they seem ever changing. So it's really great to be keeping up to speed. And I wanted to let all of our attendees know that I will be sending out or look out for an email from Michelle that's actually going to be these PowerPoint slides for you to refer back to. And beyond that, that's it for us. So thank you again for being here, everybody.
Thank you.
Thank you, Daneen. You guys take
Absolutely.
care. Stay safe
Thank
out
you.
there.